My name is Barb Van Hoy. I'm a policy analyst with the City of Colorado Springs Housing and Community Vitality Department. And it is my pleasure to welcome you and also to thank our partner organizations who make these workshops possible. Pikes Peak Library District, the Justice Center, Brothers Redevelopment, and their housing Colorado Housing Connects. And sometimes we get to also work with the Independent Center and Silver Key Senior Services. And I would be, is this actually on and working? Are you, okay. No, you're saying it should be. Hello? Hello, 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 hello. Oh, it's on. Okay, great. So in order for that to work, do I need to be right into the microphone? All righty, I can do that. We might have to keep reminding the speakers. Okay, and I also want to give a very special welcome and thank you to Representative Stephanie Vigil, who is here with us today, who has sponsored some really impactful legislation at the state level to help renters as well. So welcome, Rep. Vigil. Thank you for being here. Okay, so we are going to hear from a little bit of each of those partnering organizations because we all have some different resources to share for folks who are interested, and then we will hand it over to our legal eagle, Clinton, who will go through the landlord-tenant law. So the first up who is going to share some resources is Deb Hamilton, who is the law librarian with Pikes Peak Library District.
Hi, great, everyone. I'm going to keep this really short just because we're running short on time. So again, my name's Deb Hamilton. I'm the law librarian. I'm based out of the Penrose branch downtown where we have a legal research collection. On the back table, you'll find some of my business cards. So please feel free if you have questions after this, you need help doing some research or remembering kind of who you heard from at this presentation, feel free to reach out to me. There's also some flyers for our free legal clinic we do once a month down at the Fountain Library. That's the first Monday of every month, as well as some handouts that talk about our virtual courtrooms we have. So if you need to appear remotely for court, we have some free spaces, computers, and internet that you can use for that at the library. So thanks everyone for being here. And next up is Laura McKernan, and she's with the Justice Center.
Thank you, Deb. Can you hear me? Yes, good. My name is Laura McKernan. I'm the Executive Director of the Justice Center. We have 3 programs: Find a Lawyer to help you find legal representation when you can't afford it; Ask a Lawyer, where you can call us or email us or come to in-person events for legal advice, one-time anonymous legal advice. And we then have Learn with Lawyers, in which we help with events like today, where you will learn from a lawyer, hopefully, about new legislation and, longstanding legislation. I have some business cards that I will leave right there where all the materials are. So if you need anything from me, please feel free to go ahead and email me or call me, and I will get back to you. Thank you.
Next is Kathy Verdier with Colorado Housing Connects.
Hi, we are a organization that does lots of different things in housing, but the key reason we're here is I'm part of Colorado Housing Connects, which is a statewide helpline. We will answer questions on fair housing, rental assistance. Good luck finding that. Affordable housing. I lead a workshop every week. You're welcome to, it's on Zoom. You can do any county, but we do focus on El Paso County, I believe. Oh, no, we just did it. But anyway, you'll see it. And then, we're on pace to do 60,000 contacts this year. So hopefully we can give you some resources and stop that circle that you end up going. So I have pamphlets and things in the back.
Thank you. And for everyone who is here, who has registered and who is online, we will be sharing links to all of these organizations and their resources as well. If you don't get it, reach out to any of us and we'll make sure that you get those. I'm going to just do one little thing different here. So we know what it looks like to folks online. And if you need to move that or turn it off, you can. But just remember that that's what folks can see. Okay, just a couple more housekeeping items. These workshops we run about 4 times a year. We do have another one scheduled. If you know of other folks who want to come, or if you want to come back to another one, Tuesday, November 14th, again in person. That one will be at the City Administration Building, but also available to tune in online. Also pick up, if you'd like, one of our printed renter rights packets. We're still working on updating those with the new laws from the last couple of years, but we'll be emailing those out as well in our newsletter when that gets updated. So do subscribe if you haven't yet. Link will be coming out to you. And slides and recording will be made available. And now I get to introduce Clinton. Clinton Albert is an attorney with the Colorado Legal Services, and his entire caseload is landlord tenant. He's been there for about 4 years, I think, and 5 years now. Okay. And has a lot of great information to share. So do save your questions, and or those who are online, feel free to put your questions in the chat, and we will get to those. So come on up, Clinton, and we got your slides up. All right.
All right. Thank you, Barbara. All right. Can everybody hear me? And everybody hear me that's in the room? All right. I'm getting thumbs up. Everybody online, can you hear me? Yes. All right. Thank you so much.
That's not like sharing, so we need to do a share.
All right. 1 second here. All right. So, folks, we have kind of a hard deadline tonight of 8 o'clock. We will be getting the boot at that time. Over the last 5 weeks, there have been a substantial amount of changes and additions to the law. I will be candid. I am very nervous with Representative Vigil here in the audience that I will butcher some information about the bills, but I'm going to do my best this evening. So there are 140 slides in this slide deck. I will tell you right now, we're not going to get through all of them tonight. All right, they're there for informational purposes, but I'd like to spend tonight to focus on the new laws and be able to have a sufficient amount of time for questioning as well. All right, so just a few things to keep in mind. This presentation is for informational purposes only. Housing issues require a thoughtful analysis of both the facts and the law that may apply to your situation, especially in light of all of the new laws and protections that have gone into effect this summer. All right, a little bit better. Thank you, sir. Keep yelling at me if you can't hear me. All right. So if you do have questions, you'd like some additional assistance beyond our partner organizations, you may always contact Colorado Legal Services. Our contact information is there on the screen. You can also find us at coloradolegalservices.org. So what is new? There have been a number of changes throughout the 2023 legislative session, expanded rights within the landlord-tenant relationship. Some of these new laws and new protections do not go into effect until January. We will not be discussing those this evening because we have enough to discuss this evening that have already gone into effect this summer. So one of the largest areas has been the introduction of mandatory mediation into the landlord-tenant relationship. So mediation means an intervention in a dispute. This is the statutory definition here. It's intervention in dispute negotiations by a trained neutral third party with the purpose of assisting the parties to reach their own solution. I've been asked, well, what happens at a mediation? What could the outcome be? Well, you could come to some kind of agreement on a payment plan to get caught up on rent, maybe supplemental rules for the tenancy if there have been some issues, or an extension of a lease, things of that nature. Really, at mediation, you're only bound by your creativity and how to problem solve. For certain tenants and landlords, Colorado now does require that parties attend mandatory mediation prior to the filing of any eviction case. So who are those people? Which tenants are eligible for mediation? So a tenant is eligible for mediation if they receive Social Security income, supplemental security income, Social Security disability income, or cash assistance through the Colorado Works program. So SSI, SSDI, TANF. And minimize that down there. All right, folks, I'll pop the video here back up in just a second. The tenant discloses to the landlord in writing that they receive such assistance, all right? There we go. All right. So those are the tenants that are eligible for mediation. Not all landlords have to participate in mediation. So which landlords are required to participate in mediation? These are going to be, so landlords are required to participate in mediation unless the landlord is a 501c3 nonprofit organization that offers opportunities for mediation to residential tenants prior to filing a residential eviction court. Not just that you're a 501c3, but that you have that additional mediation as well. Or the landlord has 5 or fewer single-family rental homes and no more than 5 total rental units, including any single-family rental homes. So, a few slides back, I indicated as a tenant, you have to let the landlord know in writing that you receive this assistance. But as a landlord, you have to ask. You have to make a written inquiry. You have to take that first step. Verbal questions do not count. So this can't be a conversation in the office with your on-site manager. This has to be done in writing. So if you, as a tenant, if you receive anything in writing from your landlord, make sure to see if there's any kind of advisement on whether or not you are eligible for mediation. If you do not respond, that may be deemed by a court that you have waived mediation, and that is a situation that I would recommend against. And I'm sorry, folks online, you keep seeing that video popping in and out. I'm just trying to get all the text on the screen and admit folks into the room as well. So what are the costs associated with mediation? How do we get this scheduled? So for tenants, mediation is provided at no cost. For landlords are required to pay their share of the mediation. As far as scheduling purposes, it must be conducted by a trained third party. All right, this has to be somebody outside of the organization obviously the exceptions are the exceptions. However, the Office of Dispute Resolution is the preferred mediator, and they shall schedule mediation for the first available date no later than 14 days after the landlord's request for mediation. Here in Colorado Springs, there is a link. If you go to the ODR website, it was a little bit hidden at first, but they do have links for these landlord-tenant mediation sessions. So in an eviction case, the failure to mediate. So if your landlord did not ask you if you received one of those forms of assistance, if your landlord did not offer mediation after you told them you received that form of assistance, then that would be a defense against an eviction action. That would be an affirmative defense that the mediation procedures were not followed. And the reason that's an affirmative defense is all of this has to happen before the case is filed. So if the case is filed before this happened, then it just was, the timing wasn't right. I call it the condition precedent not satisfied. So they had to do something first, they didn't do it. All right, and that is a defense against an eviction. So the first time, and maybe you've received something in writing saying there are new laws in effect, please let us know if you receive this type of assistance. That is okay for a landlord to ask you whether or not you receive those types of assistance. And that's not in it any kind of violation of privacy or of any kind of HIPAA protections. Now, an additional new requirement here, and this goes to demands for compliance. And that is that the demand itself, let me shift this video over here. The demand itself must include this following statement: that you may be eligible for mediation if you receive this type of assistance. I'm not going to read it out loud verbatim. We have a lot of material to cover, and I'd like to make sure that I'm able to address as many questions as possible. But if you receive a demand and it doesn't have that information in it, that demand is going to be defective. Well, can this be waived? No, it can't. This will be touched on in another slide. It is an unenforceable lease provision for you to waive your right to mediation. It is also an unenforceable lease provision for your landlord to recoup any kind of fee associated with mediation. All right, now we're getting into, before we switch into rental application updates, I want to check the chat to see if there are any questions. And just to keep in mind that I am not that I cannot answer individual questions. Angela, I apologize. That question is a little too fact specific for me to answer at this time. However, in El Paso County, the question is, there's an eviction notice stating that I do not come to court. In El Paso County, the return date on the summons is what's called a non-appearance return date, meaning that if you go to court, there will not be a physical courtroom for you to go to, but you must file an answer by close of business or reach a settlement and have that filed with the court prior to close of business on the return date. Does my landlord have to have a deadbolt on all exterior doors? If so, where can I find that in the law or charter? Pursuant to the warranty of habitability, doors must have a lock. I don't know Colorado Springs City Code off the top of my head, but door and window security is subject to code enforcement as well. Any questions? Any other questions before I move into rental application updates?
Follow up on a question about.
Yes.
Them to create a settlement. They just got a notice that said that.
So if that is the situation where you've received that summons, it says you do not have to come to court. The contact information on the summons, whether that be the landlord's attorney or your landlord itself, that would be who you would contact to, sir, just give me 1 second here. That would be who you would contact to try to negotiate some kind of settlement. Yes, sir, in the back.
Okay, because we just got here and I apologize, but you're talking about eviction.
Yes.
We lived in an apartment, we were there for almost 5 years. We wanted to remodel, and so we moved out. And so far, we've spent close to $1,000 on application fees. And finally, somebody told us why we weren't getting through. And it was because apparently in 2019, the apartment complex we moved out of said that filed an eviction thing on us. We didn't know about it because we never got served or anything. And it's been well enough not to be able to get a place. But we have a letter now from the apartment complex saying that we paid in full. We were never evicted.
Sir, as the question was regarding a prior eviction, unfortunately, sir, I can't provide legal advice tonight. So that's a little too fact specific for me to get into. But what I would recommend, sir, I work for Colorado Legal Services. I would recommend applying for Colorado Legal Services. That is a question that we may be able to answer if you do qualify for services. All right. I'm not trying to blow off your question, sir, but I have follow-up questions. We don't have the time tonight.
Income verification, would that suffice if you're on disability?
Let's go through the rental application update, sir. All right, because I have a feeling we're going to touch on that issue. And for those online, that question was about income verification, and we should be able to address that here throughout the rental application updates. So these are all new laws. These have all gone into effect, some last week, some 5 weeks ago. So with rental applications, landlords are not able to ask about income, except that the income equals or exceeds 200% of the portion of the annual cost of rent that is paid by the prospective tenant. Something to focus in on there, the portion of the rent. So what does that mean? That also means that a housing voucher is required to be computed as part of a tenant's income. So if you are a landlord and you are requiring 300% rent for the 300% income for the rental unit, that is no longer enforceable. That would be in violation of the Rental Application Fairness Act. So you cannot require greater than 200%. Landlords are able to inquire about income for the purpose of determining whether a tenant qualifies for an income restricted residence. So if there's a residence that does have federal regulations or state regulations to determine income eligibility, in that situation, landlords are able to ask more than just, does it 200%?
You can't ask for
check stubs or anything like that.
Let's keep going through the slide deck. Okay.
Thank you.
So landlords are no longer able to ask you about your credit scores, adverse credit effects, events, or a lack of a credit score period, unless that landlord is required by federal law to consider a credit score or lack of credit score. Yes, sir. I don't know if who are we talking about? There's going to be organizational documents that support that organization's kind of federal funding, and it would be in those organizational documents.
If you are a landlord, is a regular person required to ask for credit score?
You are not allowed. Nope. You can well, unless you're one of the exceptions, the 5 or fewer. But other than that, you cannot ask about a credit score.
Yeah, a lot of them run your credit.
No, unless it is required by federal law to consider a credit score. 200%, sir, 200%.
No, but
I would hear anecdotally, folks would tell me, this is how much money I'm making. I can afford the rent, but they're requiring 300%. But that wasn't by law or anything. That was just kind of an accepted practice within the industry. But now the law requires that it be no greater than 200%. Yes, sir.
quickly on page 7 of the handout, it says lastly, landlords are still permitted to check the credit of the protected tenant, and
That's not accurate, sir. Sorry. The packet in front of y'all, this is my mea culpa. I have not had the time. I need to break that thing down.
2020.
Yep.
So just to follow up on what you said earlier, you made one comment about less than 5 rentals. So does the 200% and the credit score restrictions apply to 5 or less rentals?
I don't believe so, no.
Thank you.
And for online, the question was about whether the 200%, the credit scores apply to an individual with 5 or fewer rental units total. And in my opinion, it does not.
Landlord said that it sounds vague to me. Is that individual private owners, or is that also real estate conglomerates, like what we deal with?
Yes.
So they cannot ask for.
So it's 5 or fewer. That's going to be the cutoff there. And as far as the credit score, it's if federal law does not require credit score, then it can't be asked, period. All right, unless it's down to the 5 or fewer units. So this is new. There have previously been penalties for landlords who do not follow the Rental Application Fairness Act. However, the penalties previously did not include the $2,500 penalty if a landlord does not cure the Rental Application Fairness Act violation. So if you do not follow the law regarding rental applications and you are subject to it, regardless, there's going to be a $50 penalty to the applicant that you wrongfully denied or did not follow the procedure with. And if you do not fix the problem after being put on notice, that's going to be an extra $2,500. Again, to the applicant that you did not follow the procedures with. And when you were told there was a problem, you didn't fix it. Also, as an applicant, they don't have to go through other processes before they pursue those damages, and other processes would be in addition to those potential damages as well. All right, before I get into the security deposit update, which is going to be a little bit briefer, I'm going to go to just the one on the bottom. What if you have an eviction on your record? With the Rental Application Fairness Act, landlords are only able to consider rental and credit history for the past 7 years. If it is outside of 7 years, that cannot be used as a reason to deny your application. Security deposit update. This one's pretty simple. Your security deposit cannot be greater than 2 months rent. That's it. So pretty easy math there. If your rent's $1,000, you can have a security deposit higher than $2,000. This is somewhat of a larger update. And before I get into this one, I just want to check to see, is the rental application law included in the packet to explain the law? The Rental Application Fairness Act is explained better in the slide deck than it will be in the packet because the updates have not been added to the packet yet. If you have registered for this evening, I believe these slides will be emailed out to you. Yes, I'm getting confirmation. So the more in-depth information on this law is contained in the slides. Most landlords do a credit check. Isn't that considered asking about a credit score? Yes, it would be. However, that law went into effect, I believe, last week. So, Representative Vigil? All right. Thank you. So I believe that law went into effect September 7th. So I don't believe in the last week that should have been permitted. All right, let's get, yes, sir.
Does that apply for rent to own?
Oh, that's a whole different question, sir. I'd have to review that lease because a rent to own is such a different contract than just a rental agreement. So that's something where I'd have to really look into. I would want to see what the terms of the rent to own are, and if that's a security deposit, if that's equity, like a down payment equity type situation. So thank you for the curveball. The answer is I do not know. All right. So yes, sir. Both. Both. Unless federal law requires credit score be considered. Yes, sir. In back. And sorry. Folks online, the question was whether or not a landlord cannot ask about a credit score or can't deny for a credit score. And it's both unless federal law requires that they consider it. Yes, sir, in the back.
What about a tax?
Yeah, that's fine. We'll get to that in just a little bit, sir.
And the landlord says you don't get any credit. Like,
At that point, sir, you may want to contact the Attorney General's office. The Attorney General's office now has the authority to investigate and initiate civil and criminal investigations into the violation of the Rental Application Fairness Act. Learning as we go, folks, learning as we go. All right, so a lot of new lease clauses that can't be in here anymore. So the law now explicitly prohibits the following lease clauses: the right to a jury trial, except you can waive the jury trial for possession of a dwelling unit. This is going to be if you bring a warranty of habitability claim, if you bring, say, a security deposit action, if you bring a fair housing claim, if you're in the damages portion of a forcible entry and detainer action. You can no longer waive. You are not. I was just reading a lease the other day that had this in it. You are no longer able to waive the ability to join a joint class or collective legal action relating to the term of the tenancy. So that can no longer be an addendum that you waive. You cannot waive the implied covenant of good faith and fair dealing, meaning that each party is going to abide by the accepted practices within the industry. Can no longer waive the implied covenant of quiet enjoyment, meaning that when you rent a residential unit, you are able to use and enjoy that dwelling as a residential unit. There cannot be any fee for not providing a notice of non-renewal for the end of a lease, except for the landlord's actual damages. So if you're thinking back, wait a second, I signed a lease a few years ago, which said if I don't give 60 days notice of my intent to not renew the lease, I'm going to be charged 2 months rent. No, that is no longer an enforceable lease provision. It is now limited to the actual damages. What are actual damages? That's going to be the amount of time that the unit was likely vacant based upon the lack of notice. As a tenant, it's still best practice to provide that notice of non-renewal. Do it in writing. That way you have confirmation of what you put your landlord on notice of. Rent is rent. You cannot characterize other fees as anything other than what they are. Rent is rent. Rent means you're paying for the roof over your head. I'm not going to lie, Representative Vigil, this language kind of confused me. But you can no longer have a provision which requires a tenant to pay a fee markup or for a service for which the landlord is billed by a third party, except a written lease may charge a fee no greater than 2% of actual cost or up to $10 per month, but it cannot charge both.
Not my bill, but I can briefly summarize what we're getting at.
That would be great.
Okay. So,
Yes.
okay.
I would love it.
Um. So the issue here is that some landlords are starting to use third-party services like for utilities or to provide other services on their properties. And so if that is the cost of doing business for them, we're trying to avoid them shifting that onto their tenants and lumping that in as if it's your rent or just something that you use at the apartment, whether you do or not. And so hence the not shifting the fee to you and keeping it to a minimum if it is included in your service charges. Does that make sense?
That makes sense. Thank you, Representative Vigil. The last one here, I think it's the last one, a provision that allows a voucher or subsidy provider to pursue an eviction for non-payment of utilities. So again, that's kind of in the same spirit as if we look 2 lines up, rent is rent. And it's the non-payment of rent that is grounds for an eviction.
Well, that you were saying landlord, front and front, what they consider that?
I'm sorry, sir.
Like a real estate agent renting for somebody, what are they consider that?
The question was a real estate agent renting for somebody. That's likely going to be the broker.
No, not the actual person, the company itself. Like,
Yeah.
Property management company's landlord. That's the landlord.
But they don't it look like they have more rooms than a landlord person. Like a person, a human, like let's say she's the landlord, those who's allowed to her, but a real property management.
No. They apply to the property management company because they apply to the property management company. So the question was, do the rules apply to the landlord, but not the property management company? They apply to the property management company. That is the landlord. That is the organization, the entity, the person, the partnership that has assumed the landlord responsibilities for the homeowner. So they've kind of stepped in place of that homeowner, and now they have they are obligated to not include these in leases.
So why is it on zero? I see they have certain credits for they're requiring, 700 credits.
I would, that law went into effect last week, sir. So again, the Attorney General's office is able to now independently investigate and initiate civil and criminal actions for failure to comply with the Rental Application Fairness Act. So there are some new lease clauses, some new terms that have to be included. One of those is that Colorado law, and there's the specific law right there on the slide, prohibits income discrimination and requires landlord to accept any lawful and verifiable source of money. That also includes any kind of housing subsidy, any kind of voucher that you may receive. Again, this does not apply to landlords with 5 or fewer single-family rental homes and no more than 5 total rental units, including any single-family homes. Before we move into the attorney fees update, so the question is, if a landlord cannot ask about a credit score, does that mean that credit checks are no longer allowed? That is my interpretation. That is my reading of the law, that they are no longer permitted, because if you can't ask about them, then what's the purpose of checking for it? The next question is, my landlord cannot charge a fee for managing my utilities. They pay it, then charge me. They can charge up to 2% or $10 per month, but not both. So they are permitted to charge a fee, but they can't shift the entire fee.
Was it a law that was passed if you, the landlord deny you your application, you get something back?
We'll get to that in a second. That's a great question. That's going to come up in Representative Vigil's bill. You are a mind reader, sir. If I'm a landlord and my tenant doesn't pay utilities and the pipes break, aren't they at fault and can be evicted? If you are not a housing subsidy provider, then that may be an issue. But I'm getting the sense that that may have actually happened. That's a rather specific example. So it may be grounds for an eviction, but I can't state with any degree of certainty without more facts, and I can't get into that with, oops, sorry, folks, trying to get to the questions here. Where's the mouse? Plus a fee, example, $45 utility plus $5 for admin fee,
That was related to
the managing utilities. The question is, can a property management company evict you because you're on housing? No. Just going back to the idea that the tenants can skip out on paying utilities. The prohibited lease clause is that a housing or subsidy provider cannot initiate a forcible entry and detainer proceeding for the non-payment of utilities. Yes, sir.
How about in our unit, we have 24 apartments in our one building, and they share utilities. For each person, like with the neighbor downstairs has
Sir.
9 people. We have 2, but we pay more than they do.
I
know.
I'm sorry, sir. It's a very valid question. I'm not saying it's not. I'm just saying that I can't answer that question in this forum tonight. But you've got our contact information in front of you. Give us a call and fill out an application.
I have a question about utilities. So is the landlord able to require you to give them your information about the utility company? Like they want you to add them onto, we'll just say Colorado Springs Utility.
Sure.
Is it legal for a landlord to say, I need you to add me as a, you know how you can add people that.
Sure, like an authorized user. That seems odd to me. And so the question was if, thank you, Deb, or thank you, Barb. The question was if a landlord can require you to add your landlord onto your utility account. That seems, that seems, because with a landlord account, if something happens on that account and it kind of goes into default, then, and to my knowledge, CSU notifies the account, like the owner. So I'm a little, I don't know. I'll be the first to admit when I don't know something, and I don't know, but that's that's an interesting question to me. Yes, sir.
As a property owner, I believe you can be added as that backup party, so that if by chance the utilities aren't getting paid, they will call you before they shut everything.
Yeah, that sounds right to me, but adding somebody on is kind of just the same user space as you seems a little off. Does that seem off to you, sir? Like you both have the same login information? That seems weird to me. All right, for those of us online, can we obtain a copy of the written materials? If you registered for the event this evening, the slides will be emailed out. If you receive assistance of any kind, can a property manager ask about it and deny your renewal? Can't deny your renewal for receiving assistance. That seemingly would be income discrimination. All right, let's get slides moving in the right way here. So there's been an update to attorney fees. So in order for a landlord or a tenant to obtain a judgment for attorney fees, there has to be a court proceeding first. There has to be an actual judgment first. The court must determine that the party prevailed following the hearing on possession and that the requested fee is reasonable. Additionally, in the lease itself, the lease clause must be what's called a reciprocal lease clause, a prevailing party lease clause. That does not mean that you owe me attorney fees when I file this case. That is in direct contradiction of the law. You can only recover attorney fees if you win the case. Well, sorry, let me back up here. You've hired an attorney, you go to court, you win the case, the judge says you are the winner, you are the prevailing party, and then the judge determines that the attorney fees that you are requesting are reasonable. You cannot add attorney fees to the ledger upon filing an eviction. Now we get to the part that I'm really nervous about. This is the portable tenant screening report. This is a brand new introduction into rental applications. This bill was introduced by Representative Vigil. So if I get details wrong, come up and yell at me. Just grab the mic and push me out of the way. All right. So some applications require the application fee, right? However, as a tenant, you do not have to pay a rental application fee if you provide that prospective landlord with a portable tenant screening report. What is that? It's a consumer report prepared at your request as an applicant, and it includes information provided by a consumer reporting agency about about you and the date through which that information is going to be current. All right. What information is in this report? We've got your name, your contact information, verification of employment and income. I think we talked about, somebody asked about income verification a little bit earlier. So here we go in the tenant screening report. And then for each jurisdiction indicated in the consumer report as a prior residence of the applicant. And that's going to be regardless of whether that residence is reported by the applicant or by the reporting agency preparing the report. It's going to include a rental and credit history for the applicant and a criminal history record check for all convictions of a prospective tenant. In the event we don't get into the criminal convictions part, that was asked a little bit earlier. Let's start with arrest records. Never. I don't care if you've been arrested 1,000 times. If there's not a conviction, that is not a reason to deny your application. If it is a conviction, it has to be within the last 5 years, unless we are talking about homicide-related offenses, stalking, methamphetamine, generally methamphetamine-related offenses. I may be forgetting one, but if we get to it, great. Otherwise, it'll be in the slide deck.
Yes, sexual offender.
Thank you. Yeah, yes.
You're welcome. I like to help.
I appreciate the help.
You're welcome.
All right, so landlords are required to accept a portable tenant screening report. They have to accept it, but they may require a few additional things. They may require that the report be completed within the last 30 days, that the report is made directly available to the landlord by the agency or provided by a third-party website that regularly engages in the business of providing consumer reports, and that it complies with state and federal laws. That the report is made available to the landlord at no cost to use, to access, or to use in the rental application process. And also, they may require a statement from you as the applicant stating that there has not been any material change in the information in the screening report since the report was generated. Those may be things such as just kind of anything that may have happened that would change the information on the report itself. Landlords are not able to charge a fee to access or use this report. All right, so prior to any action in which a landlord is expecting has an expectation of an application fee from the prospective tenant, the landlord has to tell the tenant the applicant the following things: that they have a right to provide a screening report, and if the applicant provides a screening report, then the landlord is not able to charge an application fee or charge a fee to use the screening report. What are the advisements? So this has to be in a location and has to be in a method that is reasonably likely to reach an applicant. This can include advertisements and other public notices. It's got to be in, you're going to notice a pattern here, 12-point bold font. You cannot hide this. This cannot be hidden. 12-point bold font. It's got to be big. It can be on the homepage of a website maintained by you as a landlord or your agent. And again, 12-point bold font. It can also be in a paper or an online rental application for the dwelling unit, 12-point bold font. Or you can tell the applicant, you can tell them in person, you can tell them verbally, but then you've got to have you have to provide a written receipt that you told them verbally. I think it would just be easier to put it on the application or on the website itself. So, which landlords are exempt from portable screening reports? Landlords don't have to accept a screening report if the landlord does not accept more than one application fee at a time for the unit, or if there's kind of a multiple applicants, if they don't accept more than one application fee at a time from each grouping of applicants, and refunds the total fee to each applicant within 20 days after written communication declining to enter into a lease agreement. So that is the exception to the exemption to portable screening reports. Application denials can be electronic denials. However, if you as the applicant request that your denial, if you are denied, that it be in paper form, that has to be satisfied. You then are entitled to that paper denial as opposed to just an electronic denial. Yes, sir.
How does that work for parties like Zillow, where they're paying Zillow, like they're paying Zillow, with their applications not for them?
Well, as I would talk to Zillow to make sure that they're.
Oh.
That is right, if you're doing it on employment. By definition.
So, Representative Ehill, come here. Folks, I'm not the expert on this. We're going to call the expert in. And I appreciate it. We all appreciate it.
Yeah, no, I appreciate you. Just so we're clear, I am also no kind of legal expert. The great Mike Wiseman of Aurora helped co-write this. And I had some really, really great backup from some like longtime landlord tenant attorneys who were good at this stuff. So your question.
Okay, my question is, have to deal relative, but I've ran into this twice now. The prospective tenant can't even get their report that they paid. So they don't know how to get it to the landlord to review.
Okay, so they're still struggling with on the consumer reporting side, getting it to work for them the way that we intend it to work.
They can read it,
right?
But they can't give, like my property manager, they can't give her permission to read it.
Okay, and what service are they using for that? Do you know?
The last one was, the first one I don't know. The last one, he was applying for property and I guess the real estate company or the management company is running one of those. But they run a report for her and when she tries anything. She has to make it done.
Okay, and we know we're going to be going through like sort of an adjustment period here where like the services that exist are going from it only ever being accessed by landlords to now being initiated by the applicant and trying to share that and I know that they can because I've seen some of them do it. It's just a matter of whether or not everybody's making that available yet. And like I said, this just went into effect. So that's good to know that that's an issue. I know that like TransUnion, theirs actually works pretty well for that. You can just say invite a landlord to come access it. And like we were talking about, like Zillow just does that automatically if you apply once and you apply to multiple properties with one application. So it is kind of an adjustment period, and we anticipated that it would be a little odd here at the beginning. So thank you for
Field cover for the rent price going down.
Does what now?
The field cover for rent price going down.
I don't. It wouldn't cause anyone's rent to come down. That I
I'm saying, is that in the main or like going down the price?
Oh.
Right.
So we did run a bill this year to lift so not to impose rent stabilization or control on anyone. I'm sorry, I didn't read the question. It asked about rent control policies. Currently, the state of Colorado has statewide preemption over any kind of rent control or stabilization. Local governments aren't allowed to employ that tool, even if they wish to. We did run a bill to lift that preemption with some guardrails that the like say it's like a city of Colorado Springs chose, if they were to choose to do this, that they would have some limitations on how strictly they can limit rent increases. But that bill did not make it through the Senate. So I'm assuming we will try again, but I don't know who's running it. You're doing great. You're covering all of it.
Thank you, Representative Ehill. There was a question in the chat regarding what happens if a landlord pays for an independent third-party report on an applicant. It's a great question, Mike. We'll get to it in just a slide or two. So more updates on the rental applications, folks. So if Mike, I've got a lot of mind readers in the crowd this evening. So if an applicant submits an application and then the potential landlord obtains a consumer report, then the landlord has to provide a copy of that consumer report to the applicant and let them know that they have a right to dispute the accuracy of that report with the reporting agency. So, for example, if you have an eviction on a consumer report that is a wrongful eviction, you do have the right to contest that with the consumer reporting agency that generated that report. And again, I think you guys have heard me say this a couple times this evening. The Attorney General may independently initiate civil and criminal actions to enforce the Rental Application Fairness Act. All right, we have now gotten through a lot of the updates. There are still some interspersed into the remainder of the presentation. We're not going to get through all of it, so I'm going to skip some slides. So Mike, to answer your question, yes, they can pay for that third-party report, but then they have to provide it to the applicant. So now that we've gone through the updates, let's kind of talk about best practices and some protections and issues that may arise throughout the tenancy. So before you move into your new home, again, best practice here is to put everything in writing. A lease is a contract. This is a business document. This is a business relationship. Oral leases are valid. They're harder to prove the terms of. So best practice is to have a written agreement. Again, Rental Application Fairness Act. We've been talking about this a lot this evening. Can't charge an application fee unless you use the entire amount to cover costs and processing. That's the actual expenses to process the application or the average expense to process a batch of applications. Can't charge different amounts to different applicants. Must provide a written disclosure for the anticipated or actual expenses of processing the application, and also provide a receipt for any fee paid. Must make good faith efforts to return any remaining amounts of the fee. If, let's say, it was an estimate and it came in a little bit cheaper, have to make best efforts to return the amount of the fee or fees to the applicant or applicants. Rental or credit history for the past 7 years so credit history can be asked, credit score cannot. That it's no consideration for history that is older than 7 years. Criminal history, arrest records, never. Criminal convictions, no conviction older than 5 years, except methamphetamine related offenses generally, offenses that require a person to register as a sex offender pursuant to Colorado revised statute, homicide related offenses, and stalking. What happens if your application is denied? You aren't, like we talked about, if you request a paper notice, that has to be paper, but your landlord has to provide you with a denial that has to be electronic or in paper if you request that. Has to include the reasons for the denial, and it has to get to you within 20 calendar days of the decision to deny your application. What happens if the law is not followed? Can seek 3 times the amount of the application fee, court costs, reasonable attorney fees, and if the violation is not cured, there's up to it's a $2,500 statutory penalty. Must give the landlord notice of the intention to file the action at least 7 days before filing the action. That gives the chance to cure. If it's not cured, that's when that $2,500 penalty comes into play. Yes, ma'am, in the back.
Then, because another applicant that was unqualified, and they say that without providing me with a legitimate reason why they weren't the applicant.
The question was, can a landlord deny your application by saying that there was somebody more qualified? They would have to, I think the application would have to be a little more specific than there was a more qualified person. All right. The question was, are they obligated to respond at all? Yes, they do have to put the decision to deny in writing, whether that be by electronic denial notice or if you requested a paper notice. And that has to be provided to you within 20 calendar days of the decision to deny.
What would be considered a generic message that the landlord should try to make you feel like, you don't have to go and file a complaint?
We are denying, I don't know. The question was, what would be a generic response? Let's try this on for size. We are denying your application. Why? You have to state the reasons for the denial. Those reasons must be within the parameters of the Rental Application Fairness Act. All right.
Qualified, like you had somewhere with qualified people, one. Yeah.
Again, That's a great question. It's a great question. I would have to see that. It's that hypothetical. I would have to see. I have more questions about the letters that were sent out. I have more questions about the applications. I think that the question was, can it be disclosed to the applicant that we have multiple applicants? I think that's fair, unless you're using that in some kind of way to maybe coerce an additional fee out, right? So that would be problematic because now we're dealing with a fee that's outside the actual cost of processing.
Without running up there.
Yes.
You just clarify on the mic, $2,500 civil liability that you do not.
Thank you. The $2,500. Thank you, Representative V. Hill. But just a clarification here, it is the $2,500 is a civil liability you can pursue, not a penalty. All right. That 7-day period, that's giving you as a landlord a chance to fix the problem if whatever that problem may have been. If you are a denied applicant and you bring a meritless claim in the form of a lawsuit for the violation of the Rental Application Fairness Act, meritless, not just that you don't win, but it had no merit to begin with, then you will be liable for the landlord's court costs and attorney fees. All right, so we've turned in our application. It's approved. We've got a lease. Read it. I don't care how long it is. I know they're long. I know they're 60 pages, 80 pages, 100 pages. Every word, every line, every sentence, every paragraph. This is a legally binding contract. I didn't read it is not a defense. Make sure that you know exactly what you are signing up for when you sign up for it. And if you don't understand, you can ask for clarification. You can seek legal consultation. You've got resources at the Justice Center on Wednesday nights from 7 to 8:30. There's Colorado Legal Resources. There's the El Paso County Bar Association. But just make sure that you review the contract to have a good understanding of what it is that are your responsibilities as the tenant. What's the length of the lease? Is it month to month? Is it a year? Is it a 2-year lease? What happens at the end of that initial lease term? Is it an automatic rollover? Does it roll over from a year lease to a month to month? From a year to 6 months? What is it? What are any potential fees that may be included in the lease itself? Any responsibilities for upkeep and maintenance? I'm thinking more of a single family residence as we're describing this. It may be like yard maintenance or upkeep to that effect. Also, very importantly, if there is an issue, where do you send notices? Where do you send a paper notice? Where do you send an electronic notice? Any other rules that may be in place for the unit, because rules and regulations are going to be additional conditions of your tenancy. Those can also be potentially a reason to start an eviction case. So you want to make sure you know, hey, this is what it's required of me, and I'm going to make sure that I follow the rules here. And also it lets you know, this is what my landlord's required to do. So I'm going to make sure that they're holding up their end of the bargain here. One thing to look out for, this only occurs in written leases because it has to be a lease clause, but your unit may be what's called an exempt residential agreement. Touch all that in a slide or two. Also check any kind of warranty of habitability related sections. Those are going to be appliances, which are included in the lease, email address, website for electronic notice delivery regarding the warranty of habitability. Again, exempt residential agreement, that gives you 5 days notice instead of 10 on a demand. That has to be included in the written lease itself. So naturally, if you have a verbal lease, you're not an exempt residential agreement. Again, this only applies to single family homes, does not apply to apartments, condominiums, it only applies to landlords to a single family home leased by a landlord who owns 5 or fewer single family rental homes. So if you own 20, you cannot have exempt residential agreements. Yes, ma'am.
So what would be the, I guess, proper way to ask the landlord to give you time to make a 30, 40 page lease?
This is a very extensive document. I am aware that this is a legally binding contract that you and I are about to enter. Because I have respect for this contract and for you, I need the extra time to be able to thoroughly review this so that I understand everything that I am agreeing to. And the question was, I'm sorry, Matt, sorry, for folks online, the question was, how can you let somebody know that you need extra time to read one of these longer leases? Just, it's important. And if somebody's trying to pressure you into signing it within 3 minutes, just say, I need the time. I need the time. This is a contract. This is a business relationship we are entering into. So, you know, I would say out of respect for you as the landlord, I want to make sure that I know what I'm agreeing to. And sorry, yes, ma'am.
So are we considering, we have a mobile home park?
Mhm.
Are we considering that single family residence?
You can't have an exempt resident. Mobile home park, different.
Okay,
Because you've got the Mobile Home Park Act too, which applies to owners in the park. But if you have, I suppose, fewer than 5 rental homes, no.
we have more.
Yeah,
The majority.
that's because that's the thing. This only applies to 5 or fewer. 5 or fewer is not kind of the exception here. It is the only type of landlord that this applies to. And again, it has to be in the written lease agreement itself.
Thank you.
I'm going to check the chat real quick for questions. Can a landlord require, so Mike asks, can a landlord require a tenant to purchase rental insurance on the property? At this time, Mike, that is not a prohibited lease clause, so that may be a requirement of a lease. There is a question, if you are in a multi-unit place, what are landlords responsible for regarding maintenance? The landlord, for common area purposes, or just generally speaking, it's going to be the warranty of, that's going to be covered, warranty of habitability, Colorado Springs City Code, as well as your lease agreement itself. How do you report a landlord that is violating rights? You may contact the Attorney General. You may contact DORA. You may contact Colorado Legal Services, the El Paso County Bar Association, the Justice Center. Those would all be potential resources in that event.
Consider mobile act and those acts there for rental.
There's no kind of so the question was, is there legislation, is there a law on rent to own? Basic consumer protections. What are those consumer protections? Too many for me to list off the top of my head, and also I don't have it memorized, so I can't really get into that. That would be more of a case-by-case, contract-by-contract review. Yes, Kathy?
First-time home buying, there are housing Colorado Connect house, but also the local one. Make sure there's a house but they'll be able to.
So for those of you online, Kathy was letting everybody know that for the rent-to-own, Colorado Housing Connect does have sessions and information on that just to make sure that they're HUD compliant. Am I paraphrasing you correctly, Kathy?
Yeah.
Give or take? Good enough? All right. So, sir, earlier this evening, you asked about, rent to own. These are something to really carefully consider before entering into an option to purchase agreement. I would recommend just seeking legal counsel before signing. This is a lot, typically from just kind of what I've seen throughout my career. These are large financial commitments. And you have to, you want to ensure that you have some kind of protection for building equity, keeping equity in the home, and just kind of what happens in the event of a default. Do you lose any potential equity you've built in the home? So these are very different instruments than a lease agreement. So I would take even more time with a rent to own, an option to purchase type contract that you're considering entering into. Yes, ma'am. Mm-hmm.
That are not, they're purchasing, they don't already own it, and they're coming to someone out as a renter, it's not an obligation for them. But they do the credit requirements, but are they required to, if they're not using the base of Colorado and don't implement it. You'd have to be like, required to be a part of their program. They're qualified.
If they don't own the home, they can't sell the home.
So they purchase something.
Okay.
Basically, if you apply for homework decide based on your income and your credit and whatever else, how much rent you can afford, and then they convert that to houses that are, like, let's say $400,000 house for sale, which equal $2,000 rent. So then you get with a real estate agent, you look for homes in the market at that price. The real estate agent represents home partners as the buyer. They buy it. The tenant is not even supposed to be like involved in home inspection, real estate contracts, with their home partners customers. So that's like a little bit like, oh, way you two new. But the question is basically, can home partners as a large investment company not in Colorado require renters to meet their credit and income qualifications?
The question was, can a large investment company not based in Colorado require credit considerations in a rent to own or option to purchase? If you're entering into it as a tenant, if you are doing business in the state of Colorado, you are availing yourself of the laws of the state of Colorado. Is the simplest way I can answer that, because anything beyond that, I need to see what we're talking about here. I want to see this document that you're referring to. But if you do business in Colorado, you are subject to Colorado laws.
That they don't already have a house. Colorado. If you're entering that rental program, they don't have like.
I'll be candid. I'm completely unfamiliar with this program.
Yeah.
So if you've been noticing the confused looks up here, it's because I'm confused. So it's something that I just don't have an answer for. And like I said, I'll be the first to admit when I don't have the answer, because I'm not going to guess on these important matters.
Well, same thing. Is it worth to do a home?
Well, that's only a question that you can answer for yourself, sir. I can't answer that for you. The question was, is it worth it to do a rent to own? And that's a personal decision. All right. For some people, it might be. For others, it may not be. All right. And I'm not answering your question directly for you, because I don't know if that would be the right thing for you, sir. All right. Only you know that.
But they laid it out. They laid it out as the money that you're paying monthly is going towards the principal of the house, and once you're ready to purchase it, so that's all I'm saying.
It might be, it might not be, sir. It would depend on this hypothetical contract that we're discussing right now about whether or not a rent to own would be good for you as an individual. It's really going to depend on the terms of the contract. If those are fair or neutral. I'm getting a kind of a laugh behind you that's shaking his head, and he's telling from a real estate agent it is not. But again, that's an individual case by case determination. Also, it's going to be contract by contract determination. Yes.
And good point. And I just would add that when you buy a home, you have lots of protections in the homeowners fall behind. There's foreclosure process. You have lots of rights. It takes a long time to get foreclosure to go through. If you're doing a rent to own, you don't have those protections. So I would generally recommend traditional mortgage over a rent to own. Because what if you invest a lot into a home, you think you're gonna buy at the end, and then something happens and you then can't pay the rent for 1 month. That's it. You might lose everything you can set. So I would avail yourself of the protections that a homeowner has under the foreclosure law.
Folks online, that's my colleague, Sarah, and she was just kind of expanding on that point that generally speaking, homeowners have greater protections than renters. There's foreclosure protections for homeowners, and that generally speaking, a traditional mortgage is going to be more beneficial to you and more protected against forfeiture than a rent to own agreement. All right, I'm going to check the chat real quick. And then folks, we've got about 10 minutes before I'm going to completely turn this over to questions. So just hold questions for the next 10 minutes for me. Let's see how many slides we can get through here. All right, there's a lot. We're not going to get there, but we're going to try, y'all. All right, so you can't waive the right to the return of your security deposit. You cannot waive the warranty of habitability barring a separate written agreement supported by consideration, and you have the technical skills to do the actual work, meaning You can do electrical work. You can do carpentry work. You can replace windows. You assume that responsibility for the house. That's in a separate contract than the lease agreement, and it's supported by consideration. Maybe that's a rent deduction or something to that effect. You cannot waive the covenant of quiet enjoyment. You cannot waive a 5, 10, or 30-day written demand for unpaid rent. 30-day is a result of the CARES Act that was passed by Congress in 2020, March 2020. The 30-day requirement does remain in effect. It never had a sunset provision. You cannot waive the court process for the Forcible Entry and Detainer Act. You also cannot have late fees that are greater than $50 or 5% of the late rent. A lease cannot include an unreasonable liquidated damages clause that assigns a cost stemming from an eviction notice or an action. And I think that the attorney fees update that we discussed earlier this evening is the natural extension and evolution of this unenforceable lease provision. Look at that, more attorney fees. Can't be a one-way fee shifting clause. It has to be a prevailing party clause. We've covered this already. I'm going to the next slide. Get a copy of your lease. You have a right to it, first of all, but also you want to have that for your records. You want to make sure that you have that to reference back in the case of any dispute. Also, if you're getting ready to move out, there's going to likely be move-out procedures, and you want to make sure that you're doing what is required so as to not jeopardize the return of your security deposit. Again, get a copy. Law requires your landlord provides you with a copy within 7 days of you signing the lease. All right, so what happens now? We've moved in. What happens if your landlord changes or your building is sold? If your landlord changes, but the building ownership remains the same, the new landlord must provide you with updated contact information to include new address or addresses for a notice or notices. If this does not happen, contact them, ask them for it. If your building is for sale and your tenancy is jeopardized, you can record your lease with the clerk and recorder to put any potential buyers on notice of your possessory interest in the property. If that doesn't make sense, I would consult legal advice prior to going down to the clerk and recorder to file your lease. If there is no current lease agreement in place, then you may want to contact the new owner to propose a new rental agreement or try to negotiate some kind of extension of your tenancy. Rent increases. One time in a 12-month period of continued occupancy. That's it. Has to be in writing, has to be 60 days notice. Can't happen in the middle of a lease term. And again, it doesn't matter if this is a written agreement, doesn't matter what the length of it is, whether that's a fixed term, month-to-month tenancy, or an indefinite term. 60 days written notice to the tenant. May not terminate a residential tenancy with no written agreement by serving a notice to quit with the primary purpose of increasing the rent with less than 60 days notice. For example, please do not, if you are a landlord, please do not send out a letter saying we are terminating your tenancy in 21 days. If you would like to renew your tenancy, here is the new increased rental amount. That is specifically what this says not to do. All right. If you want to increase the rent at the end of a rent term, you are required to provide 60 days of written notice. Late fees. Yes, ma'am. Before we get into late fees. Sure. Mm-hmm. All right, let's see if we can get through late fees before I'm going to turn it over to questions, folks. All right, the following, that not allowed. Charge a late fee unless the rent payment is late by at least 7 calendar days. Charge a late fee that exceeds $50 or 5% of the past due rent. Require a tenant or homeowner to pay a late fee unless that late fee is disclosed in the rental agreement. Has to be in writing. Remove or exclude a tenant from a dwelling or start an eviction process for the removal or exclusion of a tenant from a dwelling for non-payment of late fees. You cannot evict for non-payment of late fees. You can't terminate a tenancy for non-payment of late fees. You cannot charge a late fee if a subsidy or voucher provider is late with their portion of the rent. You can't impose a late fee more than once unless those incremental amounts only add up to at a maximum $50 or 5% of the rent that is unpaid. Can't require interest. Can't charge a late fee unless you provide written notice of the late fee within 180 days after the date upon which the rent payment was due. And any lease provision that it does not comply with this statute is void. It is unenforceable. If your lease is 10 years old and you're still on it and you've got a late fee clause that doesn't comply with it, guess what? No more late fees. It's void. It's unenforceable. So any violation of this statute does have a $50 penalty for each violation. There are 7 days to cure the violation, and that time begins when written or electronic notice of the violation is provided to the landlord. If a landlord violates this statute and then they get that notice of the violation, that 7-day notice, and then they fail to cure, the aggrieved tenant may bring an action for compensatory damages for the injury or loss suffered, a penalty of $50 up to $1,000 for each violation payable to the tenant, costs to include attorney fees to the prevailing party, and any other equitable relief the court finds appropriate. It's an affirmative defense and against an eviction that the late fee statute was violated. Rent is rent. Late fees are not rent. All right, so I'm going to skip this part. Take pictures when you move in. They're really important. Try to do a walkthrough if you can. I think that's the best practice. The law does not require it, but I think it's good that you both start off in the same understanding of the condition of the place. Warranty of habitability. This is the promise that your residence is fit for a human being to live in. There are things that must be present or must not be present. Electronic notice. A work order is not notice. Electronic notice is notice by email or portal or management communication system that is available to both the tenant or landlord. You must send it in a manner that your landlord typically uses to communicate with you. If your lease doesn't say where you send the notice, send it where you typically communicate. If you text, text. Email, email. Keep copies of it. If you send a text message, screenshot it, back it up on a hard drive. You might lose that phone. It might get damaged. Maybe your text messages get wiped. You have to keep proof of the notice. What is subject to the warranty of habitability? Functioning roofs, doors, walls, windows. Plumbing that is in good and working order. Let's see if I can go up. Hot water, proper fixtures and connections to the heat. Electrical systems that are working. Common areas under control of the landlord that are kept reasonably clean and in a sanitary condition. Appropriate extermination in response to infestation. There are specific rules and procedures for bed bugs. There are lovely little friends up there in the top left. We're not going to go through bed bugs. They're in the slides, folks. If you've registered this evening, the slides will be emailed out. An adequate amount of outside receptacles for garbage, working floors, stairways, and railings, locks on all exterior doors, security devices on windows that open. There was a question earlier this evening about deadbolts. There you go. Got to have exterior locks on doors, got to have devices on windows that open. You've got to comply with all applicable building, housing, and health codes, which materially interferes with your life, health, or safety. Mold. We're not going to go through mold. Appliances. Some appliances can be used as a basis as a violation of the warranty of habitability. Think necessary things to have a fully functioning home. Refrigerator, stove, range. If the refrigerator breaks, and it was one of those fancy LED fridges, smart fridge with a TV built in, and then it gets replaced with the fridge I have in my kitchen, it's fine. It's still a refrigerator. But if you have a full-size fridge and then you replace it with maybe like an igloo cooler, no, that's not substantially the same. Condition that materially interferes with life, health, or safety. These are subjective. It significantly alters a landlord's response as far as the time to respond. I know that I'm speaking very quickly because I would like to turn it over to questions now because we've got about 15, 20 minutes before we've got to shut it down this evening. I'm going to go around the room. Let me get the online questions first here. Rate increases are for all landlords regardless of how many units owned. Yes. If you have lived in a place for years, how would security deposits work with numerous ownership changes? The numerous ownership changes, the old owner is required to transfer the funds held in security to the new owner. If the latest owner doesn't have it, that's not your problem as a tenant. That's going to be their problem, and they're going to have to find somebody along the line who screwed it up because they're going to have a claim against them. So it doesn't matter how many ownership changes there are. That does not affect your right as a tenant to the return of the security deposit or an accounting statement indicating the reasons why you are not receiving a full deposit. If the tenant portal sends me an auto message stating that my rent is late, does that count? That is not a demand for compliance. A demand for compliance can only be served in one of two fashions. It has to be in paper, first of all, and it can only be served personally or by posting if no one is home at the time service is attempted. So a automated message from the portal saying your rent is late is not a demand for compliance. Also, that does not contain the mandatory statement regarding mediation eligibility. All right, I'm going to try to speak a little bit slower now, folks. I make no promises, though. I'm going to go around the room. Sir.
I know there was a order that was supposed to be created for landlords, supposed to, so you would let the rent to you as far as posting on your credit. That permitted yet.
Pilot program for submitting rent as for credit reporting.
Okay.
Pilot program.
Sir, I'm unfamiliar with this pilot program. Yes, ma'am. The new radon regulations, in my opinion, fall under the warranty of habitability because we are talking about a condition which would materially interfere with your life, health, or safety. Also, it may be a condition that is out of compliance with building and health codes as well. So I think the warranty of habitability would control and regulate radon exposure as well. Kathy.
So all the new laws, I know that they want that retroactive, but these new laws, are they applied to your lease that you're in today or when the new lease?
The question is, do the new laws apply to your lease today? Yes. That's the law. Because if you bring an action, if you bring a lawsuit, you're going to be bringing a lawsuit under the law today, not the law of yesterday. All right. Yes, sir.
If I understand about when they do a background check on you, that the application fee or whatever, that actually the background check, you go to a reputable company, do your own background check, turn it up,
Yes, sir. We covered that in the tenant portable screening report earlier this evening.
Okay.
All right.
Thank you.
Yes, sir. You're quite welcome. And folks online, the question was about whether the question was in regards to the new law regarding the portable tenant screening reports. Yes, sir.
You may have covered this. But let's say you put in some leaves, no dog. Okay, and then in the middle of the and it acquires a dog.
Okay.
Or gets one anyway. They claim, oh, the mother's home for a dog. Whether the law or not, and they sign the lease, they were told no. They were giving
So online, the question was about whether when a lease indicates that there are no pets allowed, and then the tenant at some point during the tenancy acquires an animal that they are saying is an emotional support animal. So this is a great question. I wish we had more time to get into a lot of this, but broadly speaking, you have service animals and you have emotional support animals. A service animal is a dog or a miniature horse that is trained for specific purposes, and that is governed by the Americans with Disabilities Act. An emotional support animal is going to fall under the umbrella of the Fair Housing Act. Tenants are able to provide a reasonable accommodation request for a landlord to alter a rule in a reasonable fashion to accommodate their disability so they may gain the full use and enjoyment of the residence. I can't answer it any more specifically than that.
If it says no at the beginning, sign the lease, they agree, no, and in the middle, they get one anyways, should not the landlord be at least notified or something?
Oh yeah, that's the reasonable accommodation request.
They should be
something right, right?
Yes, so
They don't just get one and then look at it now. What rights, the tenants have what rights to the landlord have that situation.
the tenant has the right to submit a reasonable accommodation request. That has to be in writing. So to your point, sir, that's not a verbal statement. That has to be a request, a written request to you as the landlord. As a landlord, you can follow up and investigate that claim. You cannot unreasonably deny a reasonable accommodation request. So an emotional support animal, if we're looking at it as a fair housing issue, that's not a pet. All right. Yes, it is, but it's not. It is an emotional support. It is a medical device, but it is not a medical device that is regulated by, that is covered by the Americans with Disabilities Act.
Even though at the beginning,
Yes,
no pets.
yes,
6-7 months down the road.
Yes.
They just go and get one.
yep. No, I heard you.
So they have that right and no rights to the landlord.
The landlord has the right to investigate the request. The landlord has the right to make follow-up inquiries into the request. The landlord does have the ability to deny the request if the request is unreasonable. All right. I'm not trying to punt on your question, sir, but there's a lot more factual. From this point, it would be, what did the request say? You know, what are the other, it would be a lot more fact-based. It would be outside of tonight's conversation.
Right, the landlord.
Mhm.
And she got one. What rights does the landlord have?
The landlord could provide a notice, demand for compliance, but the tenant still has the rights pursuant to the Fair Housing Act, as well as the on a federal level, and unfair housing practices, which is the state level of the Fair Housing Act. But as a landlord, you have the right to provide a demand for compliance or possession if there's a violation of the lease. The tenant still has the right to provide you with that reasonable accommodation request, though. All right. In my opinion, the best practice is to put the request in writing first, but it's still able to excuse me, sir, to be done after the fact. Yes, ma'am, behind you. The question is, can anyone say my dog's an emotional support dog? It does have to kind of be documented in writing at some point, in some fashion. Folks, I'm going to move on from this subject. All right.
Do they need some psychologist, or how is it determined that the emotional support? Is there a doctor who is emotionally, how is it validated to the landlord that this is an emotional support, or do we just need to
Anecdotally, sir. So the question was, how do you determine if an animal is an emotional support animal? Do you have to have some kind of independent medical verification? So
I've got something on this.
thank you.
The Colorado Civil Rights Division does run some trainings on civil rights law and also fair housing law. And so this is federal housing law. And if you go to the state website, the Civil Rights Division, you'll see on their homepage is a schedule of their trainings. And so I would recommend those.
And sir, anecdotally, from what I've seen anecdotally, sir, most of the time those requests with a reasonable accommodation for an emotional support animal are accompanied by a statement from a medical professional to fully answer your question, sir. Yes, ma'am.
I just have a question about the income verification.
Yes.
We have naturally occurring low-income housing, so we want to make sure that people make 3 times the rent so that it's affordable for them. So I understand that it's not 200%, but is there a way that we can verify that they have that income stream?
You can
or
verify up to 200%.
Up to 200%,
Yeah.
but we can ask.
You cannot require more than 200%, but you can verify income to ensure that it meets or exceeds 200%.
Oh.
But you can't require greater than 200, but you can still check for it.
Okay, thank you.
And the question was the question was, we provide affordable housing. We like to make sure that it's 3 times the amount of income so that we know that the rent is affordable. But the new law kind of limits that inquiry just to ensure that the income is 200% of the applicant's portion of the rent. Portion is key, not the entire rent. If we're dealing with a subsidy or voucher provider, that has to be included in the calculation as well. Yes, ma'am. The question was, did we cover anything about evictions? No. No, y'all, we didn't. Yeah, I can, hold on. It's in the slides. Mold, we're still in the warranty of habitability, still in the warranty of habitability, warranty of habitability. There's the retaliation. Here's one last update for the evening. A landlord shall not retaliate against a tenant for making a good faith complaint regarding the warranty of habitability to the landlord, governmental agency, or any kind of organizing activities as well. Retaliation includes increasing rent, decreasing services, terminating a lease without the consent of tenant except as permitted by law, bringing or threatening to bring an action for possession, and taking action that intimidates, threatens, discriminates, or retaliates against the tenant. Retaliation is a defense against eviction. Code enforcement enforces the minimum city code. It does not enforce the warranty of habitability. Court is for the warranty of habitability. Code is for city code. Let me go to the online questions real quick. I know I'm back to speaking fast. I'm very sorry, everybody. I'm just trying to answer as many questions as possible. Colorado Housing Connects has an eviction prevention workshop. It's on Zoom. It is the fourth Thursday of every month. So folks, there are some additional questions online. I'm going to try to get through them because we are about out of time. Are you suggesting that landlords have to update the currently existing leases with the new laws? Any tip? I'm going to make a guess that if you've had a lease, it's going to include a statement to the effect of any amendments to this lease must be in writing and must be signed by both parties. That is going to be controlling lease language. It may be the situation. There also very well may be a severability clause in the lease, which says if any of the clauses in this lease are found to be invalid, the remaining clauses in the lease will be in full effect and enforceable. So it may be the situation where you're going to have to wait until the end of the lease term to propose a new lease agreement that complies with the law updates. Also, if you are a landlord and you're thinking, well, how do I determine what are the new updates? You can find legislative updates online. Representative Vigil, I don't know the website off the top of my head because I have it bookmarked. And they do post draft bills as well. So you can, if you are a landlord and you are concerned about that, you can follow along with pending legislation online. I am in the middle of my lease. Does my landlord need to give me an updated lease to include these new laws? I just covered that. What paperwork do I need for my ESA? It's too fact specific for me to get into. As a landlord, can they say not accepting tenants who use service animals or emotional support animals? You can do that. You should not do that. That's a bad idea. Question is, okay. So if you say you are not accepting service animals or emotional support animals, it's a fair housing violation. A service animal is nothing different than an inhaler, a nebulizer, an oxygen tank, any other medical device under the sun that you can think of because it is a medical device. Yes, ma'am. Correct. Going to depend on the law. Yep. See why I can't give legal advice? Because there's a lot of facts that go into these things, and I can spit off as many answers as I want. But if you ask me something specific, I'm going to want to sit down and have a longer conversation. Yes, sir. That you must provide a key to the landlord?
Yeah.
There is, to my knowledge, there is not a law that you must provide a key to the landlord. However, when you are moving out of if you change the locks, then you need to provide a key to the landlord.
Yeah.
Also, when you move out of the residence, courts look at returning the key as a big sign of when you've returned possession. So that's important for maybe security deposit determinations.
I'm saying though, we signed a lease, change the lock that he had over there with the own lock.
You got to give him a key. The question is, if you change the lock, do you have to give your landlord a key? Yes, you do.
Why you leave it there?
Yeah. Yes.
But it's the law.
Well, you can't exclude the landlord because there's going to be something, there's likely something in the lease that says we have the right to enter for emergency purposes. If you're out of town in a pipe burst, you want your landlord to be able to get in there and you don't want them to break the lockdown. They can't just come into your home at any time. That would potentially be a breach of the covenant of quiet enjoyment. Also, if you are a homeowner in a mobile home park, you have additional rules related to your rights to privacy. But if you are a tenant and you have changed the locks, the best practice is to provide your landlord with a key to that. Are we out of time, folks? All right. I speak fast. We had a lot of information to go through tonight. Thank you so much for your time, your questions, and your patience. I really appreciate it. And hopefully see some of y'all in November.
Thank you so much, Clinton. So, I just want to make sure that all of you here know that there is a sign-in sheet. If you had not signed it or want to receive the slides and a copy of this presentation, we also have videos on our website at the Housing and Community Vitality Department of previous iterations of this workshop that also covered more information. We can send those out to you as well. So please sign in if you didn't. And we'll also send links out again to a lot of the sponsoring organizations with more information and resources for you. So thank you again for being here and have a great evening.